SJC-12740, AMR Auto Holdings, LLC, and others, v. Matthew McGovern and others.
That's a good idea.
Yeah,
We're
isn't
gonna
it?
do it next time.
Yeah, absolutely. Thank you. This is the auto one, I think.
Mr. McGovern.
Good morning, Mr. Chief Justice. May it please the court. My name is Benjamin McGovern, and I am here today on behalf of the appellants Matthew McGovern and his company, the McGovern Automotive Group. This appeal arises from a no-hire covenant prohibiting my clients from hiring past or present employees of the Prime Motor Group for a period of 18 months. The Superior Court below enforced this covenant, but in so doing committed two fundamental errors of law that, if affirmed, will expand the universe of what is an enforceable covenant in two ways that have never before been recognized by this court. First, the Superior Court committed an error of law by creating an entirely new category of legitimate business interest to vindicate what...
Just ask you a question about this, because isn't this different from an employment restrictive covenant? We're not talking about keeping an employee from doing something once he leaves the company. We're talking about another company that's made a contract. There's an arm's length negotiation and discussion about what can be done, what can't be done, and in exchange for this, I'm going to give you that. Why can't we enforce that? Why is this not just an enforceable contract?
So what Your Honor is describing is a distinction between sale of a business and the employer-employee context, which...
But this isn't an employer-employee context, or if it is, please explain how it is.
Well, it's certainly been analyzed as a sale of a business, but what I would suggest is there's a threshold test going back to the New England Canteen decision, where this court has done a line-drawing exercise, because all of these covenants are they're inherently anti-competitive. So we draw a line. What's not enforced is something that impedes ordinary competition. And the way we police that line is we look as a threshold inquiry to whether it protects a legitimate business interest.
But can you point me to cases where we're talking about two companies making this
Yeah,
this
and I
agreement?
think the Bollinger decision, which, based on our research, was the last time this court weighed in substantively on this issue. I think Bollinger is actually instructive here, because that was a Dunkin' Donuts franchisee out in Syracuse. And that ended up being a 2-year non-compete with the 5-mile, I think, radius around the Dunkin' Donuts store. This court analyzed that as a sale of a business. But critically, what the sale of a business changes is not that threshold test about a legitimate business interest. Because in Bollinger, this court went there first, and it said, even though this is the context of the sale of a business, we still need to find that legitimate business interest. And it found it there in the reams of confidential information, donut recipes and the like, that had been provided to the franchisee. It was only then, when the court moved to the next phase of the analysis, which was the reasonableness of the resulting restriction, that the sale of a business had consequence. So in a very real sense, what the sale of a business what it does not do is expand the universe of protectable interests, which I would submit is where the Superior Court went wrong in this case. I believe the Superior Court, I would submit what Judge Kaplan did, was say, because this is the sale of a business, I have leeway to create a new business interest. I don't think that's a correct interpretation of Bollinger. It doesn't expand the protectable interest. What a sale of a business does, it expands judicial tolerance of what constitutes a reasonable restraint and vindication of that interest. And you see that most clearly in Bollinger. It's at page 644 of the opinion, where this court writes, where there's a sale of a business, geographic areas can be larger than an employment context. That's talking about reasonableness. We're talking about something different, which is legitimate business interest. And there's no question in this case that the judge made an explicit finding that this covenant was not necessary to protect those 3 traditional categories that this court has recognized in the vindication of the protection of customer goodwill, vindication of protection of trade secrets, and the protection of confidential information.
As to those 3 employees, though, only as to those 3 employees. Did he make a more general finding than that?
Excuse me?
Was there a more general finding made, or was this applicable only to 3
I
employees?
submit to Your Honor, it was hard to tell, because the way he read his findings into the record, it was a 20-minute colloquy, and it was transcribed. I believe, certainly it applied to the 3 employees he had in front of them, but if what he did, that exposes kind of what I view as an inconsistency in what he did. He found no legitimate business interest with respect to the 3 employees that left. But then what he did is turn around and enter an injunction that applied to Prime's other 1,400 employees who were not at issue in the case.
Well, I got the impression from his findings that he was not happy with your client and the behavior it had displayed in breaching this provision repeatedly. And what was he to do to keep you from doing that? He wanted to do injunctive relief. How was he going to keep you from doing that?
Well, I submit to you, he already had done it. He had entered a preliminary injunction in April of 2018, which it restrained my client. It made those contract terms an injunction up through the time of trial.
And were they complied with?
Yes.
There was no evidence of breach of those?
No evidence of a breach of a preliminary injunction, no, Your Honor.
So is what's going on here with Judge Kaplan really unique to the circumstances of this case? And he seems to be expanding the definition of legitimate business interest to fit the amount of time that these employees were working for him when they weren't supposed to be?
Your Honor, I think you're right. I think that what Your Honor is referring to applies more in the context of him extending the
Yeah,
expiration
right. That's
date,
what
which
I'm
we'll get
asking.
to in a minute.
Yes.
But I think his mistake in the legitimate business interest realm was a little bit more fundamental, because I don't believe he viewed this as a threshold test. I think he viewed this, he assumed a legitimate interest. He thought he could create a new one, very real. And then he viewed legitimate interest as something that was a factor to be considered in the way that he fashioned equitable relief. And I think that's wrong, and the reason it's wrong is that every time an appellate court has confronted a circumstance that can be characterized as arising from the sale of a business, it's conditioned enforcement on a clear link to one of those 3 legitimate interests that I've mentioned. You see that?
I'm confused, though. So you can't enter into a contract that prevents someone from stealing, basically taking the employees, key employees. Is I understand the extension issue. I'm trying to understand the original injunction did what? It prevented what in terms of hiring the other
The
employees?
preliminary injunction or the permanent?
The permanent injunction.
The permanent injunction, what it did was it took the contract terms and it extended it out for a year.
Right, and those contract term, okay, but forget about the extension. Is there anything wrong, was the contract prohibition about
I think
sort of?
I think what Justice Gaffer, I think what you're circling around is this concept. I think what you're asking me really is if I'm suggesting that this contract is void on its face, if it's never enforceable. And I'm not suggesting that, and I never have.
Okay, but, and to focus you more precisely, the provisions about taking sort of key employees, is that enforceable?
You know, it's funny because Judge Kaplan talked about key employees, and I think there's an interpretation of that could be correct. If what you mean by a key employee is it's someone that you take that could implicate your customer goodwill, trade secrets, or confidential information, then yes.
But I've read a lot of cases quickly for this week, so I may misrepresent the facts a little bit. My understanding is, for example, one of these managers, they waited until after this key business strategy meeting, and then they take him.
He never went to that meeting, Your Honor.
Okay, he didn't go to that.
No, and that had nothing to do with it.
Okay, but so then, back to sort of, I wanted to combine my question with Justice Budd's question. Is it okay to enter into a contract that prevents, after a sale, basically taking away key managers and employees, people who know the business and know how it works? And then add Justice Budd's question, which is, okay, this is then different from restrictive covenant, so is that okay? And I forget about the extension for a second.
And I will. The answer, I think, is that it could be. I can imagine a different universe where Prime could have come into court and made a showing that says the employee that you took, he walked out the door with a memory stick full of trade secrets, or he is impacting customer goodwill. He's like the Pied Piper for Subaru cars, they follow him everywhere. That could have been the facts, but it wasn't. And I think the reason, the way you know that it wasn't the facts is that Judge Kaplan had no problem concluding this covenant on the facts in front of me, it's not necessary to protect these three interests. So the answer to your questions, I think it could be, but it wasn't enforceable in this case.
Wait a minute, why wouldn't it be enforceable in this case if they're not key employees?
They were not key employees, so
Right,
there's
so
no
why should-
legitimate interest in keeping them away from my client.
But, so are you saying that your client violated the agreement because it wasn't enforceable?
I don't think there was any evidence of that. I mean,
Well, didn't McGovern take employees from Prime?
I hired
And that
one of
was,
the
wasn't that
employees.
the underlying
Well, I
agreement
mean,
between the two
it's
parties?
a little bit more nuanced than that.
Oh,
One of the
please.
employees had left of his own volition. He bounced around to 2 or 3 different places. He came to McGovern. The other one, I was working for Prime, left to go back into the general contracting business. He's doing more facilities maintenance for McGovern now. So I think it's a little bit
So you
more.
didn't take it, McGovern didn't take anyone directly from Prime?
The facts were a little different with regard to the last employee, which is the one that he had entered into an agreement to sell the dealership to,
Which
which didn't go through, and there was a lot of evidence at trial about why that was.
And that third employee was like one of their top managers, right, or top?
I don't know if I'd characterize him as top, but he was a general manager of a couple of stores up in Maine.
was somebody that McGovern wanted.
That's pretty good.
And so, but again, okay, I get it, you're quibbling whether these people are key or not, but you agree that you could enter into such a provision. And then what if we don't buy into your argument that you didn't violate it? And that, so what's a judge to do if you were violating that provision? Why is extending it so verboten? I'm just trying to make, because the judge doesn't have any alternative way of sort of making you live up to the deal. Again, I understand you disagree that that was the deal, but if there was a provision preventing the stealing of key employees and you were found to have violated it, why couldn't the judge extend it?
The reason why it dates back to all stainless and has to do with the expectations of the parties in their contracts, that when they bargain for an end date, they are entitled to rely on them. When that end date comes, it comes and that's it.
Even if it's violated egregiously? Again, I'm not asking you to concede that your client did that, but if it is violated egregiously, shouldn't we create an exception to all?
Well, there's two existing safety valves. One is that you always have your remedy in money damages, which, as we explain in our papers, that's the preference under Massachusetts law. You're required to, unless you can show your money damages would be inadequate, that's what you're required to resort to in the first instance. So that's the first safety valve. The second one goes back.
How would you prove, in this case, how would you establish the damage caused by stealing that third employee? How would you go about doing that?
There's a couple different ways, and I mean, I don't actually have to speculate because Prime did come in on the last day of trial and say, we intend to seek $3.5 million for this breach. And what that amounted to was they somehow did a back of the envelope calculation where they placed a $2 million value on what that restriction meant to them. And they said that the transfer of that employee was worth $1.5 million in gained profits to McGovern. So that's one way to do it. I think the more traditional way to do it, and probably the better one, is what's your replacement cost? What did you have to spend out of pocket to go and replace that employee? So there's certainly ways to do it. In fact, we had Prime's president and CEO on the stand, and I asked him, I said, what have you done to calculate your damages in this case? And he said, well, nothing. We're going to do it later. We'll do it as trial progresses.
What's the second safety valve?
The second safety valve is, and it's recognized in both of the EMC opinions, is that when the parties are entering into the contract, and this is very customary, they can bargain for and include a tolling provision that says if you are in breach of this agreement for a period of time, we are giving the court the equitable authority to rewrite our end date, and you can extend it for that period of breach. Prime is a
Type of discovery rule that takes
yes,
place?
well, something like
Because
that.
if your client is sneaking around and they don't, and your client runs the clock out, and you say, oh, Justice Souter said it's a 2-year period. Should there be some type of discovery rule with tolling period? And isn't that inherent in what Justice Kaplan did as far as his equitable relief?
I'm not sure if it's inherent. I quite frankly can't tell why Justice Kaplan did what he did. He said there were unique circumstances, and then he said a lot of things, and I'm not sure how I can tie it back to what he actually did. But I guess what I would submit to you, I think the findings in the record fall far short of what Prime is characterizing them in the brief as intentional misrepresentations.
I'm not suggesting that you're, or asking you to agree with those representations, but assume hypothetically that someone who is subject to a no hire provision sneaks around, the plaintiff doesn't find out about it until after the time period. You're telling me, well, you have your money damages, and they could have negotiated a tolling period.
Yes, I think those are the remedies, Your Honor.
I'm still confused. You say that you don't, you say that the anti-rating provision is not a basis that is enforceable, but you're not claiming that the agreement is void. I'm not quite sure what you are claiming.
I think what that goes back to, Justice Gans, Chief Justice Gans, is that you need to look on this at a case-by-case basis. And it's not uncommon in a non-solicitive customers that you need to look, which customers are we talking about? Are they the ones that the employee who departed had contact with? Are they customers that he didn't? So what I'm suggesting to you is that in the anti-rating context, you need to look at the employees that are moving. And do those employees trip or implicate any of those three legitimate interests? If they do not, the New England Canteen threshold test has failed. There's no legitimate interest to vindicate with any type of restriction.
So is that a matter with regard to the injunctive relief
No,
or is
Your
it a
Honor.
matter with regard, I mean,
It goes
he
to-
entered into the agreement. The first one had, he revised the agreement to make it a pretty firm anti-rating agreement, and there's at least an argument that he violated it. The judge did not find that equity justified enforcing it, in large part because the employees had relied upon they'd moved there, and there was, why should they suffer? But doesn't that mean that it's still an enforceable agreement? It may not be an agreement which is enforceable through specific performance or through injunctive relief.
I think it does go to enforceability, and I think I'd like to direct your attention to the New England Canteen decision, which was pre-Bollinger, but it resembled in a lot of ways. I think it was a food truck that went out to construction sites, and they slapped the logo on the side of the truck. It looks a lot like a franchise agreement. And what the court there said, this court said, the legitimate business interest, it's a threshold inquiry, and it goes to the enforceability, whether there was ever a breach. And in that case, this court found there was no legitimate interest to be vindicated, and the court stopped and said it is unenforceable. It doesn't matter how reasonable or unreasonable your restriction is. That's the end of the story. That's what I'm suggesting to Your Honor, that as soon as Judge Kaplan made the finding that none of those three interests were present, that should have been the end of the inquiry.
So you are saying it's void?
Void as to
Saying
the
it's
evidence that was
unenforceable.
before him.
Sorry?
And if the facts were different and we had taken an employee, as I gave the example, ran out the door with trade secrets on a memory stick, then it might be enforceable.
No, I understand. I mean, but I'm just trying to figure out, I mean, you're not saying that they're unenforceable as a matter of law in all instances, but it does sound as if you're saying it's unenforceable here under these circumstances.
Yes.
So you're saying, well, I guess the analogy, a poor one perhaps, is that non-competes may not be unenforceable apart from the new statute, but if you're going to basically say that the barber, you can't say that a barber who you fire can't work within 10 miles of your barber shop because none of the interests that we say justify such a non-compete are there, then it's non-enforceable as to him.
That's correct. And it might be different with regard to a different barber. Every case is different.
But
And
you are saying that under these circumstances, at the time that this was entered into, the anti-rating provision, even though it was agreed to by your client, was, as a matter of law, unenforceable in these circumstances.
as to these three employees that were tried, because you have to remember what Judge Kaplan broke off for trial was an injunctive trial with respect to these three. That's all that was before him.
Chief, can I ask an additional question? So I'd like to know where you are on the anti-rating provisions in general. So widget company A buys from B, their widget company, and now what they're buying in part is the quality of the employees. and then B goes out after they've sold this, and they go hire A's employees and set up widget company C. So therefore, A didn't get what it bargained for. Can you have an anti-rating provision that addresses that issue, even though it's not one of the three usual concerns for
I think it
legitimate
is.
business interest?
It can be enforced in that scenario, and I think it does fall within the legitimate interest. What you're talking about there, it's goodwill, I think. I think what you're saying, what the cases say, they've always dealt with it with regard to customers, but what you're selling, part of what you're selling in that scenario is goodwill. This case is very different, and the
Not
reason.
goodwill, it's the guy in the back who's just masterful at making widgets that nobody ever sees. And B sells the company and then goes out and hires that person in widget company C. Is an anti-rating provision okay in that circumstance?
I think it depends on the facts with regard to that employee. And I think also that this case is very different, and the reason why is at the time Mr. McGovern signed this agreement, he was already out in the marketplace competing, and there was nothing wrong with that. Prime fired him, let him go out the door unencumbered by a non-compete. So he was already out the door competing. This isn't the usual circumstance where there's a clean break.
I know, but it just gets to Justice Pudd's initial question. I mean, is it different when you're buying a business than it's simply employer-employee?
It's
That's what I'm
different.
trying to get at.
Yeah, I think the level of scrutiny that you apply to the reasonableness of the restriction is different in the sale of a business. With regard to the legitimate business interest test, that's something you still need to apply. I would suggest to you in most sales of a business, it will trip one of those boxes because there'll be goodwill or confidential information or the like. But that didn't happen here, as evidenced by Judge Kaplan's finding.
Okay, thank you. Mr. O'Connell.
Good morning, Mr. Chief Justice and Associate Justices of the Court. My name is Liam O'Connell. I represent Prime in this case. With me today are my colleagues Brian Lee and Emily Grannon Fox. This case involved the defendant's sale of an ownership interest in Prime back to Prime. In that sale, the defendant, and later, in a subsequent document, his competing company, agreed to a limited covenant that would prohibit him and his company from soliciting for hire or hiring Prime employees for a period of time, a defined period of time of 18 months. The agreement was not a non-compete agreement. As counsel has noted, Mr. McGovern was free to compete, and in fact was competing. He had already founded his own competing company at that time. It was not an employee restrictive covenant. It was entered into well after Mr. McGovern's employment had ended. In fact, the second agreement that was before the court at the Rule 65 trial last June was actually entered into a year after he had left employment. It was a limited, non-solicitation, non-hire agreement that was entered into by two sophisticated business entities. After the Rule 65 trial, the court made a number of findings of fact. Among them were that the defendant willfully ignored and repeatedly hired employees in a manner that he knew was in violation of the agreement that he had signed, and when Prime tried to enforce it by an injunctive relief earlier in this case and failed.
Can I ask you a question?
Yes, Your Honor.
So it's not a covenant not to compete. It's not an employer-employee thing. Do we have to worry about the legitimate business interest test?
We do not. I think that's the core of this case, because that domino, if you will, is everything is constructed on Mr. McGovern's side of the case on the notion that there's no legitimate business interest here. I think if the court looks at those cases, all of those cases that define the legitimate business interest, they all arise out of the employment non-compete arena. And the reason that the court thus says, hey, we're going to be restricting employees from perhaps earning a living in some manner, and we are concerned about the unequal bargaining power that may be implicit in the employer and employee relationship, and therefore, we're going to look at these agreements with a high degree of scrutiny, and we're going to require that it's going to be one of three things. It's going to be confidential information, it's going to be goodwill, or it's going to be trade secrets that can be protected, and in those cases, we'll enforce those restrictive covenants. That's not this case. This is the sale of a business or an interest in a business. And if we look at Wells, which Judge Kaplan cited to in his decision, there's an entirely different form of analysis for that. Wells tells us explicitly that in the context of a sale of business, the interest that can be protected by a covenant is expanded. In fact, that's exactly what happened in Wells. That entity was not doing business in the Fall River area, the New Bedford area, and the court
Although
granted.
at Wells, Justice Cass does say the interests which an employer may protect are trade secrets, confidential data, and goodwill. So he does, in answer to Justice Budd's question, sort of weave that in, doesn't he? In a different environment, not a employee-employer environment.
Respectfully, Your Honor, I think if you look at that, that is in the context of the employer. In fact, that's the language, the interest that the employer can restrict. That's not the case here. I think Wells and the Whitensville decision, for example, speak to the larger context or permission that a party or the court may have to enforce a covenant in a larger context of a sale of a business or an interest in a business to protect the value of the business that that entity has acquired. And even in those cases, even in Whitensville and even in Wells, we were dealing with non-competes. So we were actually dealing with the concern that we were going to restrain a competitor from competing in a particular area. That's not even the situation in this case.
I hate to interrupt you, but about those 3 employees that you didn't successfully get preliminary injunctions for, why didn't you get the injunctions? Wasn't it because the judge did not rely on legitimate business interests as a basis for your...
Correct, Your Honor. So with respect to the 3 employees, the judge was faced with a very difficult circumstance. The employees had already left the company, right? And so we were asking for injunctive relief, particularly with the last employee, where there was evidence at least entered into the record where the court could have found that that employee knew that there was a risk involved, that they would be enjoined from doing what they did, and there were concerns on our front about papers that had been filed in the court, essentially for the proposition that the company had been sold and therefore I'm not an employee of that company. But the judge made a determination that the harm to that employee, putting them out to work, given the fact that they had already moved to Maine, would not justify the imposition of equitable relief that would require the termination of that employee. But the judge did look at it and say, I've got a situation where I've got an 18-month term that was bargained for, not a specific end date, 18 months of protection, that money was paid for, where an entity entering into a business transaction said, we will not raid your workforce, and that was being willfully and intentionally violated.
So why is not the remedy that you get you seek your $3.5 million in money damages, as opposed to a remedy which says, I will use my contempt power to enforce this agreement for 1 more year? I mean, I've never heard of, that's a very unusual type of order, is to say you will be in contempt of court to hire any single employee, regardless of whether it's a clerical person or a general manager.
Your Honor, I think, I guess I'd answer that in 2 respects. First, with respect to the contempt, I think that the judge, acting in equity, made a determination based on the facts before him at trial, which included lots of evidence about what the judge, as I've already noted, found to be willful, intentional, repeated violations of this agreement, and less than candid representations to the court that frustrated Prime's efforts at trying to obtain injunctive relief. As it relates to the damages question, the 3.5 is a bit of, that needs to be, there's a lot in there. The 3.5 is not a hard number that Prime presented as a damage equation. In fact, it was presented as in the alternative when we were at trial, asking the court in equity to determine what relief it might provide to Prime to provide it the benefit of the bargain that it had negotiated. We presented the possibility that the court take a look at disgorgement as an example or restitution, and that's where.
Do you disagree with Justice Souter's interpretation of the hard and fast bargain for end date?
Yes, Your Honor. In the context of that Justice Souter's decision really emanated out of all stainless, and Justice Souter's decision in EMC and the A-copy case that was cited in that decision, all 3 of them clearly related to an employee restrictive covenant. They also related to a non-compete. But because they were an employee restrictive covenant, we believe, the court takes a look at that and says, we're limiting an employee's ability to go out and work for somebody else. And we are concerned about unequal bargaining power between the employer and the employee. Therefore, we're going to be really strict about holding the parties to what was negotiated by way of terms of an agreement, including an end date, for example. You see in our papers that we're not sure that our stainless really analyzed that, because in that case, by the time it got to the court, extension of injunctive relief extension of a restrictive covenant was not even asked for.
But shouldn't we hold sophisticated business people to the same standards? If they've negotiated a 2-year period, it's a 2-year period.
Well, Your Honor, that's exactly right. But there was not, that's exactly right. We negotiated for 18 months of no rating. We didn't get that. He willfully and intentionally violated. There wasn't some magic to the end date.
18-month shifts whenever you find out about it?
Absolutely, Your Honor, because that's the benefit of the bargain. The bargain was 18 months.
It's not from when I sign my name to this contract, it's 18 months. It's whenever I find out about it, then we're going to go to 18 months?
Well, the value of what we bargained for was 18 months. And so the court in equity could make a determination then that I'm going to issue an injunction that would take us past the date that the restrictive covenant would have otherwise expired.
What if the rating happened 2 years afterwards?
And theoretically, Your Honor, that
Then you get another 18 months? Then you get 18 months past the 2 years?
if the court felt in equity that that was going to provide Prime, or that was the best remedy to provide Prime the value of what it bargained for, then hypothetically, yes.
You say this is not a non-compete, but and just to be clear, you have no non-compete with any of your employees, correct?
That's correct.
But effectively, this agreement, which none of the employees agree to, says the 1,000 employees you have, none of them can work for this particular competitor. It does affect their opportunity to earn a living outside of your firm because it bars them from a substantial competitor. What is the interest that we consider with regard to that limitation, which the employees had no say in and never agreed to?
Certainly, Your Honor, there is some impact there. Those employees can continue to work for Prime. They can enter the general labor pool. There's a host of other companies they can work for. We think in the balancing of the interest that impact of the agreement between two sophisticated business entities that was entered into does not implicate the sort of public interest that would negate a legitimately and reasonably negotiated agreement.
Well, how would we look at it if there was an agreement entered into that you required all employees to enter into, which said, you may compete against us, but not if you go to McGovern's car dealerships?
I'm sorry, to make sure.
Let's assume you asked every employee, or as a condition of your continued employment, we require you to sign this limited non-compete. You can work for anybody else, but not for McGovern. Would we view that essentially as a limited non-compete agreement?
Your Honor, I think that would fall under the traditional analysis of an employee non-compete or restrictive covenant, and that would entail those legitimate business interests, and there would have to be a showing that there was a legitimate reason to restrain that employee from engaging in some competitive activity.
So why should we look at it differently here? Because as far as the employees are concerned, it's the same thing.
Your Honor, but the parties that entered into this agreement are not the employees. And
I understand, but we actually do care about the employees, and public policy does protect employees. So why should we view an agreement among the bosses, among the owners, that affects employees differently than we would an agreement that is directly made with the employees?
In the public interest, Your Honor, we want to encourage parties to be able to enter into agreements that are fairly negotiated. It has a very limited impact on employees. They can continue to work with Prime. They're not harmed by that. If they choose to enter the labor market, they can go to work for anywhere else. It was a limited period of time to protect the value of the business that Prime, or the interest in the business that Prime had purchased.
Did the employees know about this?
No, Your
Those
Honor.
1,000 people?
I would think not, Your Honor.
Can I just ask back about the chief's question? Forget about the number, the 3.5, okay, fine, maybe that's not the right number, but Isn't there some, don't you have to come up with reasons why money damages won't work? I mean, the judge made no findings about, money damages not being enough here.
I think, Your Honor, the judge did. We were before the judge in April asking for a preliminary injunction, which, as Your Honor knows, has the standard of irreparable harm. There's citation in the record to the judge finding in that context that, I can cite to the page of it, that the damages would be both difficult to establish in this case and would not adequately compensate Prime for the value of what it bargained for. And the judge, again, in the decision that he issued in June, cited to that in his decision that this is the case where damages will be difficult to prove and not adequately compensate Prime for its harm.
Can I ask, just factually, and I should know this, but I don't, were any other employees taken during that 18-month period? I know there's a period where there's 14 or something disappear, but in the 18-month period governed by the injunction, how many other people were poached or moved around?
So, Your Honor, the initial agreement that was signed in the fall of 2016 prohibited solicitation and hiring of employees of Prime except pursuant to a general solicitation, the want ads. Prime had reason to believe that that was violated. And there was some subsequent communications between counsel for the parties and possibility of litigation relating to that. That then resulted in the February 17 subsequent agreement, which incorporated the 2016 agreement. We think in total number, there's something on the order of 15 to 20 employees. And the 2017...
During the February time period, or I'm trying to understand what happens, forget about when the judge extends it. How many employees do we know about from, when we go through this record, how many violations are we going to find of this?
Well, the record for the trial, Your Honor, which...
Because the judge says the three don't really matter, but I'm trying to understand the total picture here in terms of, if the judge says the three don't really matter and then he gives 18 more months, it's because he's annoyed by the total conduct, but I'm not sure I understand what the total conduct is.
Yeah. So, Your Honor, first, I don't think that the judge said the three don't matter. In fact, the judge took pains to talk specifically about the third employee, who was a valued employee, who was a general manager of 3 dealerships that Prime had invested heavily in.
But he doesn't grant equitable relief because of those 3. He grants equitable relief because of the full picture, and I'm trying to understand what else is going on during those 18 months.
So the full picture, Your Honor, is that there was an agreement signed in the fall of 2016. Subsequent to that, there were a number of employees that left Prime to go work for McGovern. We would allege that there was a violation of the agreement. The court didn't find that because that wasn't before them as part of the trial.
And is that all during that relevant time period?
Yes, it is, Your Honor. So it was after the agreement was signed, there's the restrictive covenant. Subsequent to that, we have a February agreement where we have a blanket, no solicit, no hire as part of the settlement. We also agree that he can keep those 10 people that he hired. So those remain with him, notwithstanding our claims to the contrary. And then subsequent to that, there are a number of individuals, I think the total number would be 5, that leave Prime to go work for McGovern. The question then before the court, obviously, is whether you would grant relief in the form of a injunction that would prevent that person from going to work for Prime. And Prime went to court in December of 2017 at the BLS and asked the judge to issue such an injunction as to one of those employees. The judge found, I'm not going to issue the injunction, I don't find irreparable harm, but directed from the bench, if I find that Mr. McGovern actually solicits and hires a person who's actively employed by Prime that he knows is, then I would be inclined to issue that injunction. I think that's part of the backdrop to this, that what the judge is reacting to and what's reflected in his findings of fact. There's a finding that McGovern intentionally, willfully, and repeatedly ignored his contractual obligations. Perhaps under the notion that, hey, there's not a legitimate business interest here, so I somehow don't think that this is enforceable at all, notwithstanding the fact that I was paid a good sum of money for this promise.
Can I ask you a question? I'm sorry it's over, but I'm embarrassed. I don't know the answer to this question. Did this ever get stayed, or is the period over, or what? What happened to this 18-month period?
So, Your Honor, the 18-month period has, or the period of the injunction
The extension.
pursuant to the judge's order has expired. as of August, and we still have a lawsuit because there are counterclaims and other claims within the case.
Okay.
It's expired?
Yes, the
It's not-
injunction
it's
has
not moot?
expired as of August
So why
of
isn't it moot?
2019.
It's not moot?
We would take the position it's moot, Your Honor, but I think the court had expressed an interest in hearing this for reasons that go beyond just this injunction.
Okay, thank you.
Okay, thank you.
Thank you, Your Honor.
We'll take our morning break.